have John Szymankiewicz join us this morning to share some more information about trademark laws with us. And with that, I will give the screen over to you.
Wonderful. Thank you, Sarah. One of my pet projects, since I do a lot on Zoom now, is to try and find an outfit that absolutely does not work on Zoom and causes whole errors and so forth. And I think the orange tie with the blue shirt on a purple background pretty well checks that box. So sorry for any video complications you might have based on my outfit. So I am going to share my screen here in a second, but I just wanted to just want to introduce myself a little bit. My name is John Szymankiewicz. I'm an attorney with Matheson and Associates. I've worked with Shop Local Raleigh, or been a part of Shop Local Raleigh for, gosh, going on 12 years now, something like that. Had the good fortune to work on the board of directors and then as an officer position with Shop Local Raleigh several years ago. And I will say 95% of my business is working with small and independent businesses. So I really have a passion for this. I really enjoy doing this and working with folks who are really putting their lives and their livelihoods on the line for businesses. So today we're going to talk about trademark. Let me go ahead and try and share my screen. Oh, Sarah, I think I need you to enable participant screen sharing. As Sarah's doing that, I'm a very informal speaker, so if you have questions, pop them in the chat or wave at me or something. Let's try and get those answered as we go along. We'll also reserve some questions or time for questions at the end if you want. But again, if I hit something that you need a little bit more detail on or had questions about, just let me know. All right, so I'm going to share that screen. Fantastic. All right, so you all should see my PowerPoint window, and I apologize. I am going to leave it in the window and not on presentation mode, because if I do it on presentation mode, it's really chucks with my monitors. Again, trademark basics for small business. Let me move this over here. So I'm looking at all the same stuff. All right, so I already kind of talked about myself a little bit. What we're going to do today is talk about trademark basics, a little bit of process, trademark infringement, and trademark disputes. And the first thing I want to hit on is the distinction between trademarks and other stuff. I get probably one phone call a week that somebody says, hey, I need to copyright my trademark. I need to copyright my logo. And my answer is no, you don't. And here's why. Trademark is about protecting the reputation of the source of goods or services, right? So Coca-Cola, we want to protect that anything, we want to ensure that anything that has Coca-Cola on the label was actually made by Coca-Cola, right? That this is a high quality product, allegedly. And we want to know that when we see this brand on something, that we know where it came from. Now, copyrights, on the other hand, copyrights are about protecting how you can reproduce the work, right? So copyrights are for works, things like music, books, performances, stuff like that, where I do something and I want to control who can reproduce that. Right? Whether it's I can reproduce it or I sell those rights to somebody else. And then patents, which is the other big portion of intellectual property law, that's about protecting a thing, right? Something I can create, a physical object that I can create that I want exclusive rights in. And nobody else can create this thing unless I tell them they can or unless I do it. So trademarks are very different than copyrights and patents. Trademarks are commercial. You can start off with something that is copywritten, like I go hire somebody to design my logo, like the one behind me, which I actually did. I hired somebody to design that, and she created this logo. and said, okay, she has the copyrights in that logo. She created that work. I paid her to develop the work and then paid her for those copyrights. So I now own those copyrights. If I wanted to control how this logo is reproduced, I could, but because I'm in the business of selling my services, I don't want to control that. I want everybody to use that thing. I just want it to only refer to me, right? Just like the Shop Local Raleigh logo. It's not like nobody can use that. Nobody can put that on their newsletter, or nobody can talk about it in the newspaper or on television. But if they do, they need to be talking about Shop Local Raleigh. This Shop Local Raleigh, not some other Shop Local Raleigh or Shop Local Durham, for example, and they use the exact same logo. So trademark is about protecting who's behind it, what the commercial value is behind that image, that logo, that name, whatever that brand is. Okay. Next, when people say, I need to trademark something, generally they're going to, they really mean I need to register a trademark. You can get trademark rights. In fact, I think that's my next. Where is it? I'm going to come back to that. All right. So trademark rights come from use in commerce, right? You have to use the mark. You have to be selling something to get trademark rights in it. When somebody says, I need to trademark my logo or I need to trademark my name, they're typically talking about registration. And you can have federal registration or state registration. So the example I give to folks is if on Fayetteville Street in downtown Raleigh, I open Ed's Dry Cleaners, and I'm Ed's Dry Cleaners for 20 years. I'm the only one around. And in year 21, I never register anything. I never trademark or never register my trademark or anything. On year 21, somebody opens Ed's Laundromat across the street. All right, well, we're both named Ed. We're both in kind of the clothing industry. We're very close to each other. Somebody could get confused about whether whose Ed is whose, right? Oh, that Ed that opened the Ed's Dry Clean, he must have just opened a laundromat as well. We'll know that's a different Ed. And so now that Ed is now riding on my coattails. He's riding on my reputation in the community. So when we talk about registration, well, let me back up. Before we talk about registration, just by using the mark in commerce, I can get rights in that mark. As at Ed's Dry Cleaners, I never register anything, but you can see the two columns on the presentation here. There's registered and unregistered. If it's an unregistered mark, I can prove these things listed and I can still get them to stop. I can still make them stop using that mark. If I have registered my mark, I have to prove fewer things. So when we talk about registration, why do we register? We register as an enforcement tool. That's how we help push and police our rights, our trademark rights in a logo, a name, a brand, right? So along those lines, if you do register your trademark, you're still responsible for policing that mark. Nobody, the USPTO or the state or whoever you register it with, they're not going to call you and go, hey, by the way, we think this guy out in Iowa is using your trademark. You ought to do something about it. That's not their role. Once you have a mark registered, you're still responsible for making sure that people aren't abusing it, people aren't infringing on it. You just have less to prove in order to do that. You only have to prove the stuff that's listed under the registered column as opposed to the unregistered column. But should you need to prove it, you get trademark rights by showing you used the mark first, you used it exclusively for some period of time, you used it in a certain geographic area, you're the rightful owner of the mark, and people have come to associate you with that mark, right? After that, even if you haven't registered, somebody tries to use a mark incredibly similar, okay, now I can say, hey, you stop using my name or my brand, and I can show all this stuff, stop using my brand, I'll take you to court if you don't. So from a trademark perspective, we're going to talk about different kinds of registration, but we register to help enforce our trademark rights. But there are certain things that you sort of can't do, right? So you can't register a geographic place. Nobody can own the words the Grand Canyon. Nobody can own the words Raleigh. You can't register an obscenity, although that has shifted over the last 5 or 6 years with some Supreme Court rulings. Used to be you could not register an obscenity at all. Now that has started to lighten, where even racial slurs are potentially trademark eligible, and things that are not quite great, or that I wouldn't necessarily want to associate with my brand, but you can from a legal perspective now. You can't register a gesture. You can't register something that is disparagingly or falsely suggesting a connection. You can't register a coat of arms or a flag, a deceased president or a living individual. Something that is, you cannot register something that is merely descriptive or something that is generic. So for example, you can't register the words running shoes. That's just what they are. It's a script that's generic. And you can't register something like white running shoes, even though that's fairly specific to, okay, it's this pair of shoes. Well, that's still just descriptive. It just describes what it is. And I'll pick on Shop Local Raleigh since their logo is on our Zoom screen. Great example, just the word Shop Local Raleigh. There was some discussion, is that descriptive? Well, no, because Shop Local Raleigh doesn't describe what Shop Local Raleigh does. Shop Local Raleigh describes what we're trying to get people to do. Shop Local Raleigh is a group of an organization to promote local investment, local shopping, and local commerce. Shop Local Raleigh had that first discussion. Is this descriptive? No, it's not, because of what we're doing. We're encouraging people to do that, which is not what that mark is for, or not how it's protected for Shop Local Raleigh. And then, of course, the other thing is you cannot do something that is deceptively misdescriptive. So something that is deceptively misdescriptive would be something like, Belgian chocolates that are not from Belgium. That is deceptively misdescriptive. Yes, it is descriptive, but no, it's not what that is. So you're actually, in that sense, trying to mislead the consumer, and so you can't register that either. So things you can't register, but beyond that, you can register things like names, logo, we'll talk a little bit about that here in a second. Trade dress, which is an interesting idea. Trade dress is not a word, it's not an image, it's a style. And the best example of a trade dress registration is the Coca-Cola glass bottle, that kind of curvy shape that has dimples on the sides. Coca-Cola has actually registered that shape as a trademark, so that even if you didn't know anything, you closed your eyes, walked up to the grocery and felt that bottle, you'd know it was a Coca-Cola bottle. But by far and away, the most common types of trademarks registered are text marks and design marks. A text mark is the words themselves. The text, Coca-Cola, that is protected. That is a registered trademark. A design mark can be thought of like a logo. And a design mark can have text in it, but that image as a whole is what's protected. Again, the Shop Local Raleigh logo that's up on our Zoom screen, that is an image. That is a registered design mark. Even though it has text in it, that particular design is protected. However, the text by itself, Shop Local Raleigh, is also protected. So in that sense, it doesn't matter how it's written, what font it's in, what color or shape or size, the words themselves are protected, as opposed to a specific image being protected. And again, I'll go back to Coca-Cola for that. Coca-Cola owns the words Coca-Cola, no matter how it's printed. They also have a registered trademark for the design mark of that scripty Coca-Cola red, white script on a red background. That image is also protected. So those are the typical camps you end up working with folks on, or that people want to look at, is the word mark or text mark, or do I want to register the design mark? Generally speaking, the text mark is going to give you the most bang for your buck, right? No matter how it's written, what font, color, shape, or what have you, the words themselves are protected. If you register a design mark, only that specific design is protected. So for example, if Shop Local Raleigh took the word Raleigh and put it over to the side instead of at the bottom, congratulations, that image is not protected anymore because it's that specific image that's registered. So you have to be very careful about design elements, how it's used. And so working with businesses, somebody says, hey, I've got this logo, I want to register it. My first question is, how committed are you to that specific logo exactly as it is? Well, sometimes I put the name at the top, sometimes I put it at the bottom. Okay, then don't register that, or register just the text, or register the thing that doesn't have the text in it. Because if you move things around, suddenly you are starting to put images into commerce that aren't protected the same way that you maybe believe they are. All right, so basic flavors of registration that we'll talk about, or that we'll use as examples today, are going to be design marks and text marks. When we talk about registration, there's federal registrations, and that's typically what somebody says when they say trademark. They mean USPTO, federal registration. But there's also state registration. State registration has been around for a long time, and it used to be incredibly important. It has dropped off in importance in the last probably 10 years or so, thanks to the interwebs, because trademark rights come from, as you see on the side there, use in commerce. You have to be trying to sell the goods or services in commerce. Well, thanks to the internet now, it takes 5 minutes for me to put up a website and market to somebody in another state. That used to be a lot harder to do when, in order to market to somebody in another state, you had to send them a catalog, right? Or you had to send them you physically had to do something to reach out to that customer. So in that situation, trademark rights at the state level were very important. That has become less so because we're marketing much more broadly now than we were before. Even smaller and local businesses are doing much more online stuff and shipping stuff out of state, shipping stuff to other countries that are produced locally. And though we want to focus on the impact locally, that market force, or that market trend, tends to push us more towards federal registration. And that geographic area, if we're talking about federal registration, is the entire country, not that specific state. State registration, that registration or that protection only extends to the state lines. And then we also talked earlier about, what common law trademark is, or common law trademark rights are what we talked about earlier. When I ever register anything, but I just use it. And trademark rights come from this list of things: exclusive use in commerce of goods and services for a period of time in a geographic area. I can have those trademark rights without registration, and that's what people often refer to as common law trademark. Let's talk a little bit about the registration process. And I'm talking about the federal registration process here. There are two kinds of applications to the USPTO, and that's the US Patent and Trademark Office. They're the ones who actually hold the list of all the registered marks in the United States. There's two kinds of applications. And there's two kinds of applications because in order to become registered, you have to show that you are using the mark in commerce. You have to show that you're actually trying to sell the goods or services that you're associating with that mark. So let's say I start a restaurant or a bar, and I open the bar and I've got the name above the door, and I want to register the name of the bar. Great. If the doors are open, I can prove, hey, I've got menus, I've got open hours, I've got a sign over the door, I've got a website, I am marketing my bar. And I'm marketing it, I'm using that name in commerce. I'm using John's Bar to refer to my place So now I've shown I'm using it in commerce. Now I can go to a standard application, a principal registration standard application. On the other hand, what if I've got this really neat idea for a bar, and it's a, we'll call it John Sparkle Bar. Just making up a name. I don't think there's a Sparkle Bar out there. Who knows? So I've got this idea, Sparkle Bar, and it's going to be all like self-service drinks and self-pour beer wall, and it's going to be this new cool concept. And I'm out raising money for it. Well, I can't register that mark until I'm actually using it in commerce, until I'm promoting the bar with that name. But I'm afraid somebody's going to come up and steal my name. I'm afraid somebody's going to say, oh, I heard about Sparkle Bar. I'm going to do that before John gets to it. Then we've got this other application type called an intent to use. And that says basically to the USPTO, I'm not using the mark yet, but I promise I'm gonna use this mark. So it goes through almost exactly the same process, but at the end, instead of becoming registered, it becomes allowed. And we'll kind of step through this process, and I'll talk about the differences between the intent to use and the standard application. So stepping through this process, because they're very similar for a big chunk of it, that search, clearance, and opinion. You don't have to do that, but I strongly suggest it. That search, clearance, and opinion is actually a search of the USPTO trademark database, of Google, of anything that's out there. Is somebody else already using this mark? Is it registered? If it's not registered, is somebody using it? Where are they using it? How are they using it? And what effect would that have on you being able to register this federal trademark? And typically, when we talk about clearance and opinion, that's typically going to be done through an attorney's office. So for example, our office, somebody says, I want to move forward with this trademark. I say, great, we want to do a full trademark search. And then we're going to do a clearance and opinion. And that clearance is, here's what we found. Here's how it applies to your situation. Here's how it doesn't apply to your situation. Here's what I ought to do next. Here's what you ought to do next. And here's my opinion on whether or not this can be registered. A lot of folks I know, oh, I already searched the test database. It's not out there. And there's nothing registered like it. Okay. But that's not exactly how trademark registration works. Not only do you have to search for your specific thing, you have to search for stuff around your thing. So for example, let's say I'm going to open 3rd Street Bar, but there's already a 2nd Street Bar out there, and it's a registered trademark. Is 3rd too close to 2nd? Does it matter how 3rd is spelled? Is it 3RD or is it THIRD? Getting all those variations, and is there a difference between street and avenue? What about boulevard or drive? And is there a difference between bar and tap room or restaurant? And all these different permutations to look at, okay, it's not exactly the same as someone else. It's whether or not somebody on the outside, a consumer, would look at these two products or these two trademarks and be a reasonable person. Could they be confused about who owns which one, right? Or if these two products were on the same shelf together, could somebody be confused at thinking they both came from the same source, the same manufacturer, same supplier? So that's what that trademark search is about. The application is done at the USPTO. And this is typically one of those things where I'm like, if you get assistance, particularly from somebody like LegalZoom or some trademark registration company, be very careful about what fees you're being quoted, because this is the one I end up with a lot. I say, I charge, so much for this thing. And somebody says, well, LegalZoom said they'll do it for $250. I said, that may be true, but I happen to know that the application filing fee is $275 by itself. I don't think they're going to give that to you for free. So they're going to charge you that $275 plus their $250 to do that application. And by the way, did they do a search to figure out this is even registerable or not? No, that's a difference fee. So you really have to watch what you're being quoted, what you're being pitched as what you're getting. But anyway, going back to the process. So we submit an application. In a standard application, part of that application package is what's called a specimen. And that's proof that you're actually using it in commerce, right? Proof, picture of the sign over the door, or a price tag on a piece of clothing that has your logo on it, something that you can show, see, I'm using it. I'm trying to sell my goods or services using this mark. For an intent to use application, you don't have to show that. That comes in later. But for that standard application, that's the main difference between those two, is you have to show that specimen. You have to show that you're using it in commerce. After you apply, you click the submit button on the USPTO website. It's going to sit there for a while and not be looked at. About a year ago, maybe 2 years ago, that backlog for the USPTO was about 3 months. Right now, we're seeing like 6 months from the time you click the submit button until that trademark examining attorney looks at that application for the first time. At that first review, that initial review, everything could be great. This looks wonderful. This application looks fantastic. We're going to move it on to the next process. But the vast majority of the time, they're going to find an issue with your application. About 2/3 of all trademark applications are initially rejected. You may be able to overcome that rejection. And in fact, about half of those that are initially rejected do overcome that rejection and still get to be registered. But a big chunk get rejected at that initial review. And that rejection is called an office action. At that initial review, you'll probably get an office action, which says, hey, we don't think this is registerable because of X, Y, and Z. And they'll send that to you via email. You have 6 months now to respond to that office action and try and convince them that you're right. No, you're wrong. My application is registerable because we don't sell the same products as these other people. Or no, this isn't a geographic name. This is a generic name. For example, Deep River, right? We've got a brewery here in Clayton called Deep River Brewing. You go register that, or they go to register that name, and the USPTO says, no, you can't register Deep River because Deep River is a particular location. That's a Deep River in North Carolina. And we go, no, it is registerable because every state has a Deep River, and Deep River Brewing isn't anywhere near Deep River, North Carolina. So it's not generic, it's not geographic, it's not referring to a specific geography. And so you have that opportunity to argue with them and try and convince them that your position is right. Some of the main issues with office actions that come up are sometimes you have to disclaim a word, or words. So for example, if you're going to register, or if I'm trying to try and register John Sparkle Bar, they're going to say, okay, we need you to disclaim the word bar. You can't own the word bar. You can own these two words together, and as long as you use them together, but you can't own the word bar by itself. You have to disclaim that piece. Okay, fine. Or there's the geographic question. There's sometimes you'll get a rejection based on the specimen. Hey, this specimen is not sufficient to show use in commerce. Great example of that is some website, right? I'm selling widgets online, and here's my website as proof that I'm trying to sell it, under John's widget website. Well, there are specific rules for websites as specimens. For example, if you're selling goods, then you have to have on the website a button that says click to buy or add to cart and a price listed. You have to have a way to immediately purchase at that point, not I'm selling these things, call to order, call for pricing information. That's not sufficient. You've got to have that direct action. So you'll get sometimes a refusal on specimens, sometimes a refusal on geography or disclaimers. The one you really want to watch out for is a refusal based on likelihood of confusion. A likelihood of confusion rejection is one where the USPTO says, we think your mark is too close to a mark that's already registered. And if that's the case, those objections are really difficult to overcome. In certain situations you can, but it's not often easy. So a business I worked with a while back was called Primitive Coast. And there was already a rustic coast trademark registered in the same class of goods or services. And the USPTO said rustic and primitive, those are synonyms. That's almost the same thing. That's too close. You can't register both of them. You can't register yours because somebody already has rustic coast. And then we went and started arguing about it with them. When I say arguing, nicely writing letters and lawyerly arguing. And we're like, no, primitive is not the same as rustic. Rustic refers to this. Primitive has this connotation. Primitive meaning, prehistoric. Primitive meaning almost ancient. Not rustic, but rustic is very specific, and this is more general and harkens back to a different idea. So it's not just the spelling, it's the idea. What's the connotation? Not just the denotative meaning, but the way people think about it makes a difference. So that's the process that you go through in that office action response. And then you send that response back to the USPTO, they review it. And one of two things happens. Either they're convinced, great, you're moving on to the next step, or they're not convinced and you get another office action. You will get 2 bites at the apple. You'll get an office action, you get to respond to that, you'll get a final office action, you get to respond to that, and then they'll say, okay, we're done. This is where things are. You haven't convinced us. We're rejecting it outright. At that point, there are ways to try and still move that trademark along, still get it registered, but you have to take a step out of the application process and you have to actually take that matter to the Trademark Trial and Appeal Board, the TTAB, to get them to tell the examiner who you've been working with that they were wrong. So that's a whole different process. But we're going to say you do your initial review and you come up with something that, on your application, a disclaimer, you get to fix that response, reviewed, everything's great. I have seen trademark registrations get caught in that loop of review, action, office action, response, review, office action, response. I've seen things get caught in that loop for up to 2 years. Each time there's an office action, there's and a response, there's a 6-month timeline on that. So they send an office action, you've got 6 months to respond. You respond in a week, they've got 6 months to respond to you at that point. So that process can take an extremely long time. So let's say you make it through review, it's then going to be scheduled for publication. It's going to sit in that status for about 30 days. After 30 days, it's going to be published, and it's going to be published in what's called the Weekly Gazette. And this is, please don't try and print it out. It's about 3,000 pages. It's available online, but it is all the trademarks that are currently published for opposition. And that's the opportunity for anybody else who thinks they own that trademark for them to go, hey, wait a minute, Sparkle Bar, I already have that logo, or I already have that trademark. I've already opened Sparkle Bar in Dubuque, Iowa. John can't have that registration. And so if Sparkle Bar one does have better rights and was already using the mark, they put in an opposition. Hey, we oppose John getting the registration for Sparkle Bar because of X, because I already have it, or I've got a trademark registration that I think is too close, even if the examining attorney didn't think it was too close. So that's why that's published, is to offer the free world, put the world on notice. You're claiming this mark, you're trying to get this mark registered, and give somebody the chance to say, no, I don't think that can be registered or shouldn't be registered to that person because I've got rights in that mark. So it's scheduled for publication for about 30 days. It's then published in the Weekly Gazette, and it's published for 30 days. After the 30 days of publishing is over, the opposition period stays open for another 30 days. So that somebody who saw it on day 29 of the publication period or published period still has time to file that opposition. After the end of the opposition period, if nobody opposes it, it'll be scheduled for registration. And it's going to be scheduled for registration for about 30 days, and then it will become registered. If, on the other hand, somebody does put in that opposition, the registration process is put on hold, and there's a whole legal process for arguing about that opposition. Hopefully that doesn't happen to you. I've only had it happen maybe 3 times in the last 10 years with marks that I've been working with. But that, one of the reasons that doesn't happen is doing a good search and clearance and opinion earlier. So now the difference here in between the intent to use application and the standard application is, like I said earlier, with the standard application, you have to prove you're using it in commerce. With an intent to use application, you don't have to prove that yet. It goes through exactly the same process, only after the apposition period, instead of scheduled for registration, it's scheduled for allowance. And at the end of the process, it's allowed, it's not registered. And the way I kind of think about that is when you show you're using it in commerce, it will be allowed to register. So it's an allowed mark. And from the time it's allowed, you have 6 months to show use in commerce, or you can get it extended for another 6 months. And you can keep extending it for a total of up to 3 years. But if at the end of 3 years, if you haven't gotten a statement or use, or if you can't provide proof that you're using it in commerce, then your whole application, everything is abandoned. It goes away. So why would I do that? Why would I file that intent to use application? Well, the good news here is if you file that intent to use application, you go through this process, your trademark protections date back to when it was allowed, not when you actually started using it. So for a standard application, your USPTO registration protections date back to when it was registered. But for an intent to use application where, okay, I'm going to work on Sparkle Bar and I start in July of 2022, and I don't get to open my doors until July of 2024. Well, if I've gone through this intent to use application, even if somebody else opens something called Sparkle Bar before I do, I can probably make them stop as long as I become registered. I can go back and go, no, you knew I was doing this. You knew the world was on notice. You should have known that I had a mark application in and had been allowed for this for this mark. Shame on you, you should stop. And I can actually go after them for infringement if it's after I was allowed, but before I actually started using the mark, as long as it later becomes registered. So they talk about it as a way of holding your place in line. Even if you're not ready to use it right now, you can keep other people from putting a flag in it and taking it out from under you. So the other part I wanted to get through with going down this process discussion is this is not a quick process. Best case scenario, best case, you're looking at probably 9 to 12 months from the time you click submit on the USPTO website until you're registered or allowed. And we're seeing that, like I said, drag out even further now. Honestly, the USPTO is blaming it on COVID. They said, well, people were stuck at home. Everybody started to try and do new things, start other businesses. They just had a flood of trademark registrations. And what used to be a 3-month backlog is now close to like a 6-month backlog for even anybody being able to look at your mark to see if it can be registered. So plan ahead. If you are going to be opening your business in, say, the next 3 months, 3 to 6 months, I'd say just wait and do a standard application. If you're going to be opening your business in 6 months to a year, or certainly more than a year out, I'd file an intent to use application. Now, on the other hand, I would only think about filing a for a registration if you have something that's worth protecting. Because again, once you're registered, it's incumbent on you to police that mark. If you're not going to go out and stop other people from using it, is it worth protecting? Is it worth registering? Because if you don't police your mark, eventually you will lose the ability to police that mark. And the example goes like this. I register Sparkle Bar, and the next year Sparkle Bar opens up in the next town over that's not me and is clearly, infringing on my trademark rights. I don't do anything about it. And then I don't hear about them for a couple of years. And then I heard about them and I don't do anything about it. After 3 to 5 years for that, if I still haven't done anything about it, I lose the right to do something about it. The legal argument is called latches. And it's essentially, hey, if it were important, you'd have done something about it. But you're asking now, even though you knew about it way back then and didn't do anything, you let them go ahead and keep using that. No, you can't stop them now because you've let them go on too long. So you have to police that mark in order to keep your rights in that mark. If you know about somebody using it and don't do something about it, at some point you will stop being able to do something about it through the legal system. Okay. So let's see what's next. I want to talk about that likelihood of confusion stuff, right? How close is too close, right? So I talked about Ed's Dry Cleaners and Ed's Laundromat earlier, about Sparkly and Sparkle, dry cleaners and laundromat. There's a whole list, and if you ever have a hard time getting to sleep one night, look up something called the Dupont Factors. And the Dupont Factors are a list of between 7 and 9 categories that you have to consider when looking at likelihood of confusion. And those things are things like, are the spellings similar? Are the look of the words similar? Is it one word or 2 words? Is it hyphenated? Is it not hyphenated? Is it the commercial impression, which is like that connotation thing I was talking about? And I'd say Sparkle and Sparkly are very similar. Those are really similar ideas. Are they similar products? And even if they're not similar products, are they sold in similar situations? So trying to think of a good example there. So let's talk about impulse buying. So when you're going to the grocery store, assuming we all don't get it delivered these days, but you go to the grocery store and there's this whole stack or whole counter right next to you of like candy bars and magazines and batteries and phone chargers. Oh yeah, I need that too. And you put it in your cart or put it on the belt and buy that as well. So those are impulse buys. You're not doing a lot of research on those. That's an impulse purchase. So let's say there's Duracell batteries on the impulse buys thing right there. And I'm going to start a new company that makes cellular phone chargers. But I'm going to make them really rugged, like out of stainless steel braiding, and they're not going to break or bend. You can get them wet. They're really durable. And I'm going to call them Duracell chargers. All right, so timeout. Duracell batteries is going to come after me and go, wait. 1, that's our exact name, so you can't use that. 2, I'm like, no, they're completely different products. You don't make phone chargers. I don't make batteries. They're totally different. But they're sold in the same situation. They're sold at the same places in the same time. They're all impulse buys. They're sold right next to each other at the grocery stores or in electronic stores or at cell phone stores. People are going to get confused because the chain of custody, the route of distribution, how it's sold is too similar, even if the products aren't similar. Okay, so that causes things a problem. Some of these other examples here that don't matter at all. The difference between Rockford Co. and Rockford Company, those are exactly the same words or same mark as far as the USPTO is concerned. And slight spelling changes where it's, there's a capital F for the Rockford. No, same thing, doesn't matter. Or let's see, my favorite example is like 3rd Street, THIRD. If I did TH3RD, that's still 3rd, and that's still exactly the same mark as far as the USPTO is concerned. So slight spelling variations, making it a little bit different, like Drizzly, great example. They're an alcohol delivery company, or what's the other one that I just the other day was thinking about? Lift, L-Y-F-T. It's still lift, and it still has the same connotation. Even though it's Y, it's going to be treated like lift. And so if you're starting a company for ride sharing called Lift Me, or I Need a Lift, guess what? That's not going to be far enough apart, because lift is still, you're still going to compete with LYFT as lift. The next one down here on the list is Enigma services versus enigmatic services. Oh gosh, those seem really similar. But I'd say, no, wait a minute. An enigma is a problem, right? Or a mystery, or something you got to figure out. Enigmatic has a slightly different connotation. It's like, it's an enigma is a thing. Something that's enigmatic is a descriptor. It's mysterious. It's not a mystery. It's curious. It's not an enigma. It's not a problem. So is there enough difference there to be able to argue? And I'd say I wouldn't want to do it, but there isn't an argument to be made that those are different enough that you might be able to get that registered. The next one down, though, foreign language equivalents. Caution is the English word for Achtung in German, or vice versa. Achtung is caution in German. So as far as the USPTO is concerned, those are exactly the same mark. Foreign language equivalents qualify. Evil plant nursery versus devil weed nursery. Okay, well, they're both nurseries, so that doesn't help. Evil plant versus devil weed. I think you could probably argue that those are different enough, because we're talking about weeds versus plants and evil versus devil. Devil is a singular idea. Evil is a more broad abstraction. I think you could work that out. Same with Dead Man Restaurant and Undertaker Restaurant. They're different enough ideas. Dead Man, well, it's a corpse. Undertaker, well, that's the person who takes care of the corpse. Those sort of things. But then what about something like strike bar and strikeout bar? Those are really close. Yes, there's an out, but if they're both sports bars, ooh, that's going to be really hard. That's going to be really hard if you're say strikeout bar, and you own strikeout bar and it's a registered mark, and somebody tries to register strike bar. Ooh, that's tough, because the strikeout literally contains their entire mark, right? There's no separation. You're actually just it's a piece of that other mark. That's probably too close if the goods or services are too closely aligned. So that's kind of a flavor of that likelihood of confusion and why trademark stuff is not necessarily intuitive. This is kind of, I won't say squishy, but it can get into a lot of detail about, was that too close? How's that used? What's the connotation? How do people think about it? What are the routes of distribution? How is it sold? All those sorts of pieces. And that's sometimes why you want to have an attorney help you with this registration stuff. So that's kind of on the text mark. The next one I've got is, here's how they look at images, right? So we're talking about designs or logos. This was an interesting case from about 6 or so years ago. These are two breweries. I work a lot with breweries and wineries and so forth. And one, I don't know if everybody remembers Magic Hat number 9. It was real popular about 5 or 6 years ago. That's the mark on your right. West 6th was a brewery, I think in Nebraska, something like that. And that their logo was on the left. And Magic Hat said, hey, wait a minute. This wasn't even a registration. West 6 wasn't registered. This was an infringement case where Magic Hat, your 6 logo looks a lot like our 9 logo. They've got almost the same font. So the 9 is really looks like the 6 upside down. And we've got a pound sign, but you've got a star. They're both round. You've got text around the outside. Sometimes we put text around the outside. We've both got this wide border. Your 6 is pushed up against the side. Ours isn't, but we've got these squigglies that attach it. And so this is the level of discussion that it comes down to. How close are these? And if I know Magic Hat number 9 was a registered mark, If West 6 came to me with this logo and said, this is the mark we want to register, I'd say, no, don't do that. Go find a different mark. Go do something different, because you're inviting them to come say, you ripped us off. You're trying to make your package look like ours, so somebody will think it came from us and they buy it, instead of thinking that it's our product instead of your product. So that's the level of discussion around, okay, from a planning perspective, I'd say, no, get a better designer, be more creative. You don't have to make it look like somebody else. Do something different. As opposed to, if this is already in play and we've now got a dispute, how do we handle those disputes? Okay. Which comes up to the next piece. An element, when I talk elements of claim, those are the elements of infringement where, hey, you person, you're infringing on my trademark rights. Okay, what does that mean? Well, if I go to sue that person to get money or make them stop or something like that, these are the elements, these are the legal elements I have to prove in order to win at court, right? First, the mark deserves protection of rights. It's not generic. It's not something that is dilute, right? It's not generic, and it's not so widely used that everybody uses it anyway. Like, it's a good example. Well, no, that's registered. Struggling coming up with an example, but you see them all the time. Aquarium supplies, right? Or some generic name that you've seen. Oh, I've seen it in like every town, but I know it's not the same people. Oh, there's a perfect El Rodeo Mexican restaurant. There must be at least one El Rodeo Mexican restaurant in every town I've ever been in, right? That would be too dilute. Everybody's infringing on everybody else. Nobody has any better rights to anybody else because it's just used all over willy-nilly. So it's too dilute to try and protect rights around that particular name or mark. But the mark I'm trying to protect or trying to stop somebody from infringing on deserves protection of rights. And I used it first. I used it exclusively in the area. I'm the rightful owner of the mark. This other dude is using a mark. That mark is too similar to mine. The other mark is used without my permission. So it's not like I licensed him the mark or I let him use my trademark. And I was damaged as a result. He's taking business from me, right? Or he has a really bad product. And so him using that mark that's too close to mine makes my product look bad. So that's what you have to prove in order to win if you go to court. If you are registered, number 1, 2, 3, and 4 on this list are sort of already taken care of. The presumption of registration is that 1 through 4 are, the USPTO has already done that. The USPTO has already said, yes, we've looked at the mark and it deserves rights. You were the first one to use the mark because you applied for it first. The geographic area is the entire United States. And 4, we've registered you as the owner of the mark. So that's it. Now all I have to do is prove 5 through 8 at court and I win. But it's a presumption. They can say, unless they show something really different, I'm right on those. However, if let's say I go and say, hey, dummy, you're using Sparkle Bar and that's my registered mark and you need to stop. And I take them to court and I go, look, I've got my trademark registration certificate. I'm registered. 1 through 4, I don't have to worry about. Wait. When did you start using Sparkle Bar? When was it registered? Oh, it was registered in July of 2022. And they go, oh, but we started using Sparkle Bar in 2020 before you even opened. Oh, so I didn't use it first. Oh, okay. So if they can prove that, they can overcome that presumption. They can still reverse that proof. It is merely a presumption. It's weighted in your favor. And sort of that's why I refer to trademark registration. That's an enforcement tool. It's just a tool in your toolbox of how you manage your brand. It's not going to stop anybody from using or stealing your ideas or your mark, but it's a way to help you keep them from doing that, or punish them, or stop them from stealing or infringing on your mark. When we talk about disputes about trademark issues, right? I own Sparkle Bar, and some town over opened up Sparkle Bar. All right, I need to do something about that, because like I said, if I don't do something about it, eventually I will lose the ability to. So what do? And I've kind of just given a thumbnail sketch of what you should expect, cost-wise, to do something about this, right? A cease and desist letter with a demand, hey, stop using that, change your sign in the next 30 days, stop using Sparkle Bar. That's pretty cheap. You can do that yourself. You hire an attorney to do it, but a few $100s. That's not too bad. Response to that, negotiate, stop using the mark, or if somebody says you're infringing on their mark, they're coming after you. Okay, we can negotiate, we can talk, we can say, okay, yep, you're right, I'm going to stop using the mark, my bad. That doesn't cost a lot, right? It may cost you some money to redo your sign, or redo your marketing materials, or your printed stuff, or your website. But in the grand scheme of things, what we're going to talk about may not cost that much. And oftentimes, where I've represented somebody who a trademark owner is coming after my client, and I've got to try and sort this out, most of the time trademark owners will say, okay, fine, just stop using it, burn through what you've got, and change your name. You got 6 months, burn through all your materials, and we'll give you some time to change stuff, but you've got to stop. Just give us a timeline. Okay, so that's not too bad. That's that respond, cease, negotiate, etc. At some point, you may get lawyers involved, right? I have this posturing and yelling by attorneys. I will tell you that for some reason, trademark attorneys are like the biggest bullies I've ever seen. Maybe it's because this stuff is kind of soft and squidgy. Oh, it's too close, it looks like mine, that sort of thing. But if you get a cease and desist letter from an attorney for a trademark issue, it's typically going to say something like, you're an evil person, you did this intentionally, you're hurting our product, we're going to come after you for everything you're worth, your mother's going to be out on the street, you're going to lose your house, just all this horrible stuff. Part of that is just to get you to pay attention, honestly. But that posturing and, not bluffing, but puffery or puffing up, our situation, it's part of the negotiating process. It's a negotiating tactic, and still isn't going to cost that much. Second demand letter, hey, you ignored it, still not too much. Okay, once they've intentionally ignored you and not doing anything about it, no matter which side you're on, if you're defending, it's going to start costing you more money because you need to get a lawyer involved. If you're trying to protect your rights, again, probably need to get a lawyer involved. So costs are stepping up. You file a lawsuit, costs step up again. An answer, you're defending against that lawsuit. Money starts to creep up a lot more because now I've got to go do something about this. Discovery gets to be really expensive. That's where I go to, if I'm trying to protect my mark rights, I go to the other side and say, hey, I need all your sales receipts for the last 2 years since you've been using and infringing on my mark. I need you to provide all the design information about how you designed the mark, who did it, when they did it. I need you to send me all emails and all correspondence related to the use of the mark other than to your attorneys. A lot of information goes back and forth, and it takes a ton of time, especially attorney time. And so costs creep up again. You can always settle. So my settlement talks are a small dollar number. You can always settle. That doesn't cost you much. If you have to take this to trial, be prepared to spend real money, right? So I would tell folks, if you are a registered trademark owner, and I'll pick on Shop Local Raleigh again. Shop Local finds out that there's a Shop Local Dallas that's using that exact logo and just replaced Raleigh with Dallas. And we go all the way through this. I'm going to have, and they want me to represent them. I'm going to have a conversation with Shop Local Raleigh and go, look, I'm going to suggest you figure out a way to resolve this. Because if you want me to sue them, one, it's going to have to be in federal court because it's an issue, or be in a federal registration. And two, because it's another state. This is an easy $40,000, $50,000 in cost and attorney time and legal fees and discovery and all that stuff. Easily going to cost you $40,000 or $50,000 easily to fight this and to get to trial and get a judgment. That does not include people to actually enforce or collect on the judgment. So let's say we go through all of that and the judge says, you know, Shop Local Raleigh, you're right. Shop Local Dallas, you intentionally infringed on this. You owe Shop Local Raleigh $100,000. Judgment's entered. Well, now you still have to go get that money from Shop Local Dallas. That's a whole, what if they don't have it? How are you going to collect it? What if they just go, okay, yep, you got a judgment. Come take our 4 laptops. Those are the only assets we've got. You know, we'll file for bankruptcy. We're done. So even then trying to collect or enforce whatever judgment can be a problem. So, you know, especially for small and independent businesses, trademark disputes can be a huge concern. Can be a huge drain on financing. And that's whether you're trying to defend against something or trying to police your own mark. Again, that's why I say don't register something, don't use something unless it's worth defending and policing, because you're talking about potentially a considerable amount of money going into this. Now, again, I'd say at least 95% of the trademark disputes that I've worked with in the last 10, 12 years never get past that lawsuit filed. We've always settled it. We've always, you know, sorted something out, but it still costs money, and oftentimes more money than somebody really wanted to spend on this. So you do have to be careful about what you're doing and what you're going to try and what your goals are, I should say, out of this. So then I want to talk about what I consider soft resolutions. A lot of times, especially small independent businesses, if you can just talk to the owners, talk to the people involved, not through their lawyer, not through, you know, some president, manager, you know, some delegate. If you can just talk to the owners, you can probably sort something out on your own. Or, you know, half the time, some of this infringement is just good faith mistake. I'm sorry, I didn't realize, I didn't even think to check there, or I never did a Google search, whatever. And then you go, okay, look, no worries, I understand, just stop using the mark. I'll give you 6 months to change your website and, you know, pick a different name. I'll check back with you in 6 months. If you can start with that level of discussion, you're probably going to be better off. If you reach out to them and the next thing you get is a letter from their lawyer, that's a bad sign, because they've already pulled the lawyer involved. You might need to get legal assistance at that time if you can. But even when you're just, you know, reaching out by phone or email or something, document everything, even if it's by phone. You know, keep a journal or a notepad. You know, called, you know, Carlos on this day, left a voicemail, asked him to call me back. Called Carlos on this day, followed up on voicemail, didn't get it here. He wasn't in the office, asked for a call back. Called Carlos on this day, talked to him. He said it wasn't an issue. I disagreed. I said I'd follow up, and, you know, document everything you can, because that could be really important later if it does move to litigation. It's really hard to recreate that information later. So document during the time, and make sure you're talking and focus on what you care about, not what's yours. And so I have a lot of conversations with clients about this around, do you really care that there is a cafe in Knoxville, Tennessee with the same name as you? Well, yeah, I don't want people to get confused. Okay, are people going to get confused between you in Raleigh and them in Knoxville, Tennessee? Maybe the answer is yes. Maybe it's absolutely, because this is just one of a franchise thing I'm going to start doing, and the next one is going to be in Asheville, and the next one after that in Gatlinburg. And I mean, yes, it's a huge problem. Okay, cool. We'll go down that road. If it's not, Maybe the answer is, well, okay, tell you what we're going to do. I own that registration. I own Sparkle Bar, and you are operating a Sparkle Bar in Tennessee, in Knoxville. I'm going to license you my mark. I'm going to let you use my mark for free, as long as you agree not to open another location. You will never operate anywhere else but your current location. You won't expand. You won't open another Sparkle Bar. You won't, you won't come to North Carolina. You won't come go any out paying me, right, or sorting something out. Then I've effectively kept them just there. That's all they can do. And honestly, again, for an independent business, that's efficient, unless they have big plans, in which case they're going to want to work with you anyway because you own the trademark. So focus on what you care about, not you have to stop. Because again, these are probably other small businesses in large cases, or in most cases. And don't dig in. You really want to keep your options open, especially if it's a local potential infringement. I've done some really neat, like collaborative marketing for infringement issues, where it's, okay, you're using a name that's really close to mine. I need you to change. Tell you what, why don't we do like a fundraiser together and use that as an announcement for your new brand, and we'll donate the funds to charity, right? I'm not making any money off of it. You're not making any money off of it. We do a splash. You get your stuff. I get a little bit more business. You get more business with your new brand, and people know that we're different. And we both look good because we're giving back to the community. That's a win-win, right? Try and keep your options open. Also, be very careful what you do on social media. I tell clients, always, always, always take the high ground. You do not want to be the one who is that bully who says, you're a mean, evil person and your food is crap and you should, I don't want anybody to know anything about you because they might think it's me, because it doesn't take much to get that stuff reposted to social media. And now you look like the bad guy. So you do always want to take the high ground. Hey, I'm open, willing to work with you, but I've got to protect my rights, or I'm willing to work with you, but I need to protect my investment in this. Even if I made a mistake, I'll change my brand so I get off of your registered trademark, but I need some time. So be careful what you say to whom and how you use social media, because you don't want to come off as that bad guy, because that then causes more difficulty for you in the long run from a publicity standpoint. But don't be bullied. Firm but fair, right? All right. And when you're trying to find a solution, it's about balance. Your time and theirs, your money versus theirs, time in the market, how strong is the brand, how broad is the brand, how deep is the brand, and those are different, depth and breadth. What's the reputation worth? What's your integrity worth? How people look at you and how people perceive you and your brand. How much inventory are we talking about here? And then what I call the snark factor. The snark factor are those folks who believe either A, all publicity is good publicity, which I don't believe, or B, I'm going to make you look like a jerk. That doesn't bode well for good and, getting to a resolution amicably. If I publicly make you look stupid, you're much less likely to work with me and get to an outcome that I think is favorable, right? And I always look for find a solution. These are the things that if you can find these in your solution, it's going to get you a good result. It's easy for them to say yes. It lets them save face. It's low effort to implement, takes the high road, nobody's making anybody look bad, and develops relationships instead of burning bridges. Especially if it's a local competitor, you want to have a good relationship with those local competitors, not a crap one, right? I've had issues, I work again a lot with breweries, where even competing breweries, they're not far from each other. One will go, oh my God, I ran out of this. Do you have some of this hop or this grain that I could borrow for a couple of days, to make this recipe. I got it on order. It's just not going to get here in time, or it was delayed. That stuff, I've seen it happen, especially in good local communities where businesses have good relationships with each other, even though they're competitors. Because my personal belief is a rising tide lifts all boats, but focus on opportunities to build relationships, even if that all comes crumbling down. You can always go back with, but we were in the right. We tried to be good. We tried to be nice. We tried, look at all the things we did to make this work out. And they were the ones who didn't want to be nice. They were the ones who wanted to be a problem. They were the ones that forced us to file a lawsuit. That's a much better story than being the big bad people who filed the lawsuit because you wanted to mess with somebody or something. So think about those things as you're looking at resolving trademark disputes. I will also say, I probably should put this up earlier. This is one of my favorite labels ever. The label actually says cease and desist, which is kind of funny. Some things to bear in mind. When you register your business name with the Secretary of State, that carries no trademark rights. That means literally nothing from a trademark perspective. That's not the same as your state trademark registration or federal registration. There are certain government entities, I've listed a couple here, TTB and ABC, those are alcohol examples, but there are certain government entities that just because you can register the name with USPTO doesn't mean you can use it on your product, right? So I'm trying to think of a good example for food, for instance. Oh, there's a good one. If you say something like Raleigh seaweed as the registered mark, and it's a food product, let's say it's brownies or something, but it actually has no seaweed in it, that could be an FDA labeling problem, right? Because or an FTC consumer problem, because you're leading people to believe that that's in the product and it's not, right? So just because you can register it doesn't mean you can always use it. There may be other legal issues there. And the other one, when we're looking at trademark registration, is there's this concept of related classes. So for example, I put the example here of construction. Construction is one class of services, right, that people can register in. John's Builders. Professional services is a different class of goods or services, but they're related. So let's say I'm going to use Sparkle again. Sparkle Construction and Sparkle Architecture. Ooh, if I saw those two signs together on a construction site, right, on a construction site fence post, would I assume they were the same company? Yes, yes, I would, even though one's professional services and one is construction. And so when it's a related class, the USPTO will say, no, those are too close, even though they're different classes of goods or services, the ideas are too close to similar. One of you cannot register. So that's another kind of like nuance or twist on this that you might want to, sort of pay attention to. And with that, I think, yes, oh, thank God, I'm at the end. That was everything that's on here. I will make these slides available to Sarah and Shop Local Raleigh. If anybody wants a copy of the slides, happy to give you those. I am going to go ahead and stop sharing now. However, there it is, stop sharing. We've got a few more minutes. Anybody have any questions I can help answer, or details about what we've kind of gone through today? Again, very quickly, that's like a brain dump about trademark stuff into an hour and 15 minutes. I hear crickets.
Well, thank you, John. I know that was a lot of info to go over, so I appreciate you taking your time and giving us the rundown on trademarks. I learned a lot from it. So.
Well, I was going to say, again, because there's a lot there, feel feel free to call, email, whatever. My contact information is on the slides. I'll get those to SLR. And our office, we don't charge for an initial consult. So just call and ask, what about this? What are you talking about here? How would I do that? If there's ever anything we can do, just call and happy to follow up. Or if you have questions after this, what the hell were you talking about? Why is this different than that? Let me know. Happy to help out or answer any questions as they come up.
Awesome. Well, thank you so much. I really appreciate everybody joining us this Tuesday morning. We will get John's slides posted and the recording of this onto our blog. If anybody wants to review it, and as John suggested, reach out to him with any questions that you might have about trademarks. So with that, we will send everyone off. So thanks again for joining us for Tech Tuesday, and we hope to see you next month.
Thank you so much.
Take care.